Hello, good evening and welcome to another program on Law and Order. Now, most of us know about the new Inland Revenue Act, or we call it the Tax Act in common terms. But this law, which was written into Sri Lanka's legislature recently, we don't know what we are in for in it. And tonight, we thought it's the best time to tackle the areas of the new Inland Revenue Act, and for that matter, all matters relating to tax as much as possible in this program. So, like always, we invited a guest, and my guest today is an expert on tax laws and the new Inland Revenue Act. He is none other than Suresh Perera, attorney at law and a specialist on tax law. Suresh, thank you very much for taking time off and on such short notice coming to the show. How are you doing today?
Thank you for inviting me, Chanakya.
You're doing good. Right, before we start on the new Tax Act or whatever, could you give us a brief history about the tax culture and the laws in Sri Lanka?
Okay, tax culture and the laws in Sri Lanka. Let me start by giving a brief history with regard to the income taxation in Sri Lanka. I think it was in 1932 that the Department of Inland Revenue was established for the first time, and the first tax statute was the Income Tax Ordinance number 2 of 1932. And from there onwards, there have been many taxes introduced and taxes abolished. And if I focus on income tax, after the 1932 Act, there was another act that was introduced in 1949 and in 1963 and 1979 and in 2000 and the current act of 2006. So now it is this current act, Inland Revenue Act number 10 of 2006, that is to be replaced with effect from the 1st of April 2018 from the new financial year. Well, if you want me to talk about the tax in general, we have maybe 20 to 30 taxes. We have direct taxes, we have indirect taxes, VAT, NBT, you call that stamp duty, so many taxes. So we have very, very fascinating web of taxes.
Right. Before I ask you we go into the new Tax Act, why was the reason that the new act was necessary?
Okay, let me put it this way. We do have a very rich tax culture and many tax statutes, but at the same time, I keep saying that the tax system in Sri Lanka has evolved or developed like the road system in Colombo. From time to time, whenever the taxes were required, when the government was short of money, statutes introduced, and we find that now it's a web of taxes. It's difficult for a person to sometimes even understand. So it's complicated. So I think everybody wants the tax system simplified. And at the same time, though we have so many taxes, Sri Lanka does not collect enough taxes because we have problem with regard to the tax to GDP ratio. We have problem with regard to the income tax to GDP ratio. It's not generating sufficient revenue. So the purpose of introduction of this particular act, what they point out, there are 4 bullet points. One is basically the generation of the revenue and to ensure that more income tax is collected. Then second one is, of course, the simplification. Tighten the tax administration. Now, those are the purposes or the objects of introduction of this new Inland Revenue Act. But you have to wait and see to what extent these purposes or the objects would be fulfilled. We have to keep our fingers crossed. We should not be negative, but at the same time, we should contribute to ensure that this could be properly implemented, because this is for the betterment of our nation.
Right. Now, you mentioned about the taxes, a very important point about that enough tax is not collected. And people do have this notion who lived abroad, that Sri Lanka is in a way a tax heaven. Right? Do you agree with this?
Well,
so far, up to the new act. Which
no, I won't agree that Sri Lanka is a tax haven, because we do have so many taxes. Take the case of corporate tax. The standard tax rate is 28%, and the highest tax, certain companies go up to even up to 40%, and the concession rate is 15%. So we do have a fairly average tax rate, and at the same time, there are so many other taxes also. You have to keep in mind that value-added tax is going at 15%, NBT is going at 2%. So we have so many taxes. So we do have a tax cut. I won't put it as very excessive, but we do have a reasonable tax system.
Right. Now, what is the present status of this act which has passed? When is it going to be effective?
Well, this act or the bill was issued on the 19th of June and it was passed in the parliament on the 7th of September.
Yeah.
In between, according to the constitution, you know, when a bill is presented, any party who has any grievances or any interest has been given the right by the constitution of Sri Lanka to go and challenge a bill in the Supreme Court.
Yeah.
So exercising that right, many parties approached the Supreme Court, and I think altogether about 10 cases were filed.
Yeah.
And the Supreme Court gave the determination to the Speaker, and taking into some of those the points given by the Supreme Court, after accommodating all that, the act was passed on the 7th of September. The important thing is, on that date there was many committee stage amendments that were introduced, and now the status is that after introduction of those committee stage amendments to the bill, it should be certified by the Speaker, and then the document should be available from the Publication Bureau or the government printer as the final document. So we don't have that document because the committee stage amendments have not been incorporated and signed off by the Speaker. So that is where the current status is. But this will come into effect, as I pointed out, from the 1st of April 2018 from the new financial year.
Right. Now, you said several cases were filed on this, and Supreme Court made certain changes. What were the concerns about those people who filed, and what was the Supreme Court's thinking? Okay, the original draft.
Okay, there were many cases. I will not go into detail, but let me give. There were about 4 cases filed by, in fact, by the trade unions of the Inland Revenue Department as well. And there was one concern in relation to a particular phrase in the section in the Act, where the Commission General had the power to delegate his powers to officers. So that I think the concern was whether, acting under that particular section, the Commission General would delegate his powers to an outside party. So that has been addressed by specifically amending, saying that the delegation of power should be to a tax officer. So in addition to that, again, from the point of view of the taxpayers, there was a provision where Commissioner General had power in the bill to prevent a taxpayer from going abroad by issuing an order. So the power was with the Commissioner General.
Yeah.
In the current Act, Commissioner General does not enjoy such wide powers. If a Commissioner General, for whatever reason, wants to prevent a taxpayer going out of the country, then the Commissioner General must make an application to the magistrate, obtain order. Thereafter only the Commissioner General could prevent the person from going out of the country. So now that status quo has been, the Supreme Court gave the determination in favor of the applicant, so the status quo has been restored. In other words, going forward, if the Commissioner General wishes to prevent a person from going abroad before payment of the taxes or before filing of the return, he must obtain a court order from the magistrate and then carry out that order.
Those are the main 2 changes that were made.
There were so many.
Yeah, so many.
In relation to
right.
that.
So anyway, now with adopting all that and passing this bill, what does the government hope to achieve with this?
Well, of course, it's basically the increase of the tax revenue and the simplification of the tax system, widen the tax base, improving the tax administration. That's the broad objective.
Right. When you say improve the tax revenue, what are the new, now you would have seen the Act, what are the new areas that you feel will be taxable which were not taxed before?
Okay, let me put it this way.
Yeah.
When you look at the current Act, you can see if, there are many tax exemptions in relation to the tax people, in relation to transactions, in relation to industries. Right now, for instance, section 7, 8, 9, 10, section 13. Now all those sections go on to give exemptions or concessions or reliefs. Now in this Act, all that have been taken out, and only selected areas have been given relief or exemptions. So the main difference between the current Act and the Act to come is basically the restriction of the exemption. I think that's a fair statement to make.
Right.
So there are so many other changes, differences also, but I would say this is one of the main.
Would you mind taking us other changes if I may
Yes,
ask?
of course, there are changes in relation to the procedural matters, in relation to the withholding tax rates, so on and so forth. If I give you an example, let's say in case of something affecting general public, right now a person who makes a deposit in a bank, when he is receiving interest, that interest is exempt, that interest is subject to 2.5% withholding tax. After 1st of April, it will increase to 5%. In relation to
any interest in bank, FD inclusive.
Yes, interest. And of course, there right now there is a, how do I say, controversy or the debate that's going on in relation to the NRFC interest, RFC interest, etc. The current act, as the bill stands, those exemptions are not there.
Those exemptions are not there.
That means in the right now in the current act, NRFC interest is exempt, but in the bill,
it's not exempted.
It's not exempt.
You also mentioned that procedural changes are there. What are the procedures? Means collecting procedure or?
Okay. Let me start from the payment procedure.
Okay.
Right now, how we pay income tax is on self-assessment basis.
Right.
That is the main method procedure given. What is meant by the self-assessment procedure? That is basically we estimate the income for the year, and in 4 quarterly payments we must make the payment and then make the final payment on the 30th September and file the return on the 30th November. But at the same time, there's another clause in the Inland Revenue Act to say that if you pay at least 1/4 of the previous tax liability as the quarterly payment, then the person will not be facing or exposed to penalty. Now that procedure is changing to say that going forward, we call it the previous year basis. So the previous year basis is going out. In other words, every person must estimate the income for the year and then pay it in 4 quarterly payments. When you are paying the first quarterly payment, you must file an estimate of the income for the year, profit for the year. And under certain circumstances, Commissioner General has also been given the power to disregard that, not disregard, to say that a particular person or a class of persons need not file that estimate and he give the estimate. So the taxpayer must take that estimate and pay to the Inland Revenue Department the relevant tax given by the Commissioner General. So that's wide power given to the Commissioner General.
Right. Now, one of the things that crosses everybody's mind is, you said 2 purposes of the government is increasing the
tax revenue
and also simplifying the procedure. Now, are these what is the procedure they have simplified? Is it like a electronic mechanism they're going to bring in, or what?
Okay, now let me put it this way. There are so many things happening in the tax arena in Sri Lanka. It's not just the introduction of this new Inland Revenue Act. In relation to tax administration, I think we are seeing how do I say, not a revolution, big change taking place in relation to the administration, because there's a scheme called RAMIS, Revenue Administration Management Information System, that is being introduced, a process that is being introduced at the Inland Revenue Department to ensure that there will be computerization in relation to tax administration, which may go on to improve the efficiency of the tax administration.
Right. Okay. Now, Sri Lanka is driving towards a lot of investments, right? With the BOI, which has been there for so many years, and now the megapolis projects are coming up, and so on and so forth. Now, is the foreign direct investment affected by this new tax act, or the tax holidays given to foreign direct investments under BOI legislation and other legislation is still there?
Okay, very good point that you raised. Let me put it this way. In the new act, there's nothing called a tax holiday. Right or no? Because
to anyone, to a foreigner or Sri Lanka.
Foreigner or Sri Lankan, the word tax holiday is not there. But at the same time, there are other mechanics used in the act to give tax concessions to the investors, but no tax holidays. With regard to the companies and persons who are enjoying tax holidays, there is a specific provision to say that those tax holidays will continue, will not get affected. If there are any BOI agreements entered into by companies, and by virtue of that agreement, if that particular company is enjoying the tax holiday, they need not worry, that tax holiday will continue. But at the same time, there is this is section 9 of the Act, which says that no other law can be enacted to, contrary to the provisions of the Inland Revenue Act, to grant tax holidays. So, only tax holidays could be granted only by amending the Inland Revenue Act. So, take the case of SDP. SDP is a, how to say, SDP is a regime, Strategic Development Authority Act regime, where tax holidays could be granted. Now, after 1st of April, the government will not be in a position to use that procedure or enact another statute to grant tax amnesties or tax holidays contrary to the provisions of the Inland Revenue Act. It is only by amending the Inland Revenue Act the tax holidays could be granted. So, in other words, we are coming to the era of tax holidays after 1st of April.
Ending of tax holidays.
Granting of new tax holidays.
New tax holidays.
Yeah, right. Existing tax holidays will continue. That will not get affected.
But do you think, this may be a little bit beyond the law, but is it healthy to bring that kind of thinking, writing into the law, given the fact that Sri Lanka is eternally and still trying to get more and more and more of foreign direct investment to build up its country, whether it's the railway that we are thinking, or megapolis projects, or the port city, or other things. Is it healthy? Is it timely to bring this kind of law?
Okay, it's a question that you should put to an economist or a politician, but let me put it from let me try to explain something. The school of thought that investors do not look at the tax holidays when they are making the investment decision.
Right.
Foreign investors, they look at the certainty of the tax system, they look at the political stability when they are making the investment
decision. Yeah.
And at the same time, there is this concept called tax competition. This is basically nations or the different countries competing with each other by granting tax holidays to attract FDI. Yeah. And in the process, what happens is you are running a race to the bottom.
Right.
You understand, basically. So from 1978, we have been granting many tax holidays, very long tax holidays, and the current thinking, I would say, it's not due to this new act. During the last 3-4 years, we have formed the opinion that tax holidays are not that productive for Sri Lanka. But having said that, in relation to the FDI or the foreign investors, there are other means by which tax incentives are being granted. For instance, there is this concept of accelerated depreciation or enhanced depreciation, and giving tax deductions, multiple tax deductions. Now, these techniques are how the provisions pertain to these measures are there in the Inland Revenue Act. So, if a foreign investor is to be given a tax concession, the government can bring the investment under one of those sections and give the exemption.
Right. Now, protection of taxpayers, rights of taxpayers. How does this act differs from the old act with regard to the protection?
Okay. let me put it this way. Yeah. Now, this act grants wide powers to the Commissioner General to ensure for better administration. I said in the last question I mentioned that one of the points of introduction of this new act is to ensure better tax administration. I think it's coming from that point, because of that there are wide powers granted to the Commissioner General compared to the current act. Now, one I already explained. That's the case of Commissioner General being given the power to give estimates to taxpayers with regard to the making quarterly payments. When the Commissioner General makes an order to a person or a class of person that this person must make the quarterly payments according to this, these amounts must be paid at quarterly payments, he has to make the payment. He has no option. And if he does not agree, and if he does not make the payment on the due date, the normal penalty procedure comes in. So, there is no right to the taxpayer to appeal against that order given by the Commissioner General. So, that's one aspect.
Yeah.
Okay,
So right is affected in a way.
Yeah, in other words,
Negative way.
yes.
Yes.
So that differs according to the, I would say, the holder of the office.
Oh, right.
If he acts reasonably,
Yes.
that will be that will be productive.
Oh.
But at the same time, if
So
he
no
acts
right to appeal from decision of the
not right to be in relation to this particular, function, right?
function, okay.
So in addition to that, let's see, the right of representation. That's basically where the taxpayer has the right to be represented by an authorized representative. Now in the current act, that there's unqualified right for any taxpayer to make representation to authorized representatives. But in the proposed act, the new act, that is qualified to a certain extent because the Commissioner General has the power to specify the circumstances under which the taxpayer can bring his authorized representative.
That qualification not specified. It's an attorney or a tax license tax advisor?
No. Let me explain this. This is basically circumstance,
Right.
two different things.
Yes.
The particular section in the act says that the Commissioner General must specify the circumstances and the designation of the person in relation to the representation. But at the same time, in the interpretation section, the same old definition, who is an authorized representative, is there. So we are not bothered about, we don't have to worry about this issue with the who can be an authorized representative. It's only the point is basically the Commissioner General has the power to specify the circumstances. So if he may say, okay, in relation to this matter, you can come with the authorized representative. But at the same time, in relation to this particular issue, you must come alone. So now that I think is not required.
Not required. Right. The appellate procedure, is it differing from the previous act to this one?
Yes, there is a change. Now, what do we have in Sri Lanka now? We have 4-stage tax appellate procedure. First appeal is to the Commissioner General, thereafter to the Tax Appeals Commission on a question of law to the Court of Appeal, and from the Court of Appeal you can appeal to the Supreme Court. That's the final stage, again on a question of law. So we find the relevant portions with regard to this 4-stage tax appellate procedure, first part in the Inland Revenue Act itself, and then there's a separate act called the Tax Appeals Commission Act. Now in the new act we find this concept of appealing to the Commissioner General is not there. It's not appeal, it's the term used is an administration review. A person can make application for administration review. Within a period of 3 months, the Commissioner General must give the determination, and if he fails to give the determination, then the taxpayer has the right to appeal to the Tax Appeals Commission. Right. Now there was issue with, I think in one of those cases that I mentioned also, this issue was there when the Commissioner General raises an assessment, he must give reasons for raising the assessment. This is a concept coming from the rules of natural justice and included into the tax statute. It's what we have right now. So in the new act, this duty to give reasons is not there. But somehow in the committee stage amendment, the government has accommodated a particular phrase to say that the basis of the determination should be given. So basis of the assessment should be stipulated. So we have to wait and see how this, what's the difference between the phrase basis of a basis and the reasons. And at the same time, right now when we appeal to the Commissioner General must give the determination within a period of 2 years. And if the Commissioner General fails to give the determination within a period of 2 years, the appeal is resolved in the favor of the taxpayer. Now, in the current act, the 2-year time bar is not there. So, Commissioner General can take any number of years to give the determination, which is not very healthy.
Exactly. Now, from the entire interview, I gather, among other things, that Commissioner General has been given very wide powers under the new act. Who is appointing the Commissioner General under the new act?
Commissioner General is appointed by the Minister in charge of the subject of finance.
He doesn't have to go through a vetting procedure of Parliament or like the justices are appointed.
No, it's basically it's the powers with the Minister of Finance to
Minister
appoint.
Of Finance. Right.
So I think you are trying to refer to this. What you call the Constitutional Council.
Council, yeah, there is no such requirement.
Commissioner General need not go before the Constitutional Council according to the framework.
Okay, final question. I said it's a final question, but give me in 30 seconds, tell me, what is your opinion on this act? If it is a fair question to ask, what is your opinion on this act? Your personal opinion on the new act?
Okay, it's a difficult question. I have mixed feelings.
Yes.
There are a lot of technical issues that should be resolved during the next 6 months.
Yes.
I think the government must be open with regard to getting the feedback from the taxpayers and improving the act. And going forward, we all have to, how do I say, expect that this act will bring the desired result, because as I said, taxation everywhere, nobody likes to pay tax, but at the same time, for the betterment of everyone, the taxes are necessary. Every government has to collect the taxes, so we expect that this will work.
Suresh, Perera, thank you very much for joining Law and Order today and for those very valuable thoughts. I wish we had more time to discuss with you, but we are running out of time. And thank you. We hope to see you once again on this subject.
Thank you, Chair.
Thank you very much. And that's Law and Order for you today. We'll join you next week at the same time with another program on Law and Order. In the meantime, you can join our conversation on the Facebook. That's Facebook/Law and Order Channel I. And you can post your questions and comments. And you can also go to Channel I website, channeli.lk, and go to the program Law and Order and watch these programs and our previous programs over and over again if you like to. Have a good weekend, have a good night, and enjoy the rest of the programming on Channel I.